Welcome to our annual training on sexual harassment prevention. My name is Melissa Houghton, and I am the Director of Human Resources at CWI. In recent years, the topic of sexual harassment in the workplace has been brought into the national spotlight, bringing with it a renewed awareness about the serious and unacceptable nature of these actions and the severe consequences that follow. The term sexual harassment may mean different things to different people depending upon your life experience. Certain conduct that may have been acceptable or seemed acceptable in the past may not be acceptable today. The purpose of this training is to set forth a common understanding about what is and what is not acceptable in our workplace. New York State has long been committed to ensuring that all individuals have an equal opportunity to enjoy a fair, safe, and productive work environment. Laws and policies help ensure that diversity is respected and that everyone can enjoy the privileges of working in New York State. Preventing sexual harassment is critical to our continued success. Sexual harassment will not be tolerated. This means any harassing behavior will be investigated and the perpetrator or perpetrators will be told to stop. It also means that disciplinary action may be taken if appropriate, and that disciplinary action may include termination of employment. Repeated behavior, especially after an employee has been told to stop, is particularly serious and will be dealt with accordingly. This training will help you better understand what is considered sexual harassment. It will also show you how to report sexual harassment in our workplace, as well as your options for reporting workplace sexual harassment to external state and federal agencies that enforce anti-discrimination laws. These reports will be taken seriously and promptly investigated with effective remedial action taken. What is sexual harassment? Sexual harassment is a form of sex discrimination. It's unlawful under federal, state, and where applicable, local law. It includes harassment on the basis of sex, sexual orientation, self-identified or perceived sex, gender expression, gender identity, and the status of being transgender. It is also unlawful when it subjects an individual to inferior terms, conditions, or privileges of employment. Sexual harassment includes unwelcome conduct which is either of a sexual nature or which is directed at an individual because of that individual's sex when such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment, even if the reporting individual is not the intended target of sexual harassment. Also, when submission to or rejection of such conduct is used as the basis for employment decisions affecting an individual's employment. There are two main types of sexual harassment that we will cover: quid pro quo and hostile environment. Under New York State law, harassment need not be severe or pervasive to be unlawful, which means critical, serious, or widespread. Any of the harassing conduct described in this training can be unlawful unless it is shown to be no more than petty slights or trivial inconveniences. A hostile environment on the basis of sex may be created by any action previously described, in addition to unwanted words, signs, jokes, pranks, intimidation, physical actions of violence, either of a sexual nature or not of a sexual nature, directed at an individual because of that individual's sex. Hostile environment sexual harassment includes sexual or discriminatory displays or publications anywhere in the workplace, such as displaying pictures, posters, calendars, graffiti, promotional material, reading material, or other material that are sexually demeaning or pornographic. This includes such sexual displays on workplace computers or cell phones and sharing such displays while in the workplace. This also includes sexually oriented gestures, noises, remarks, jokes, or comments about a person's sexuality or sexual experience. Hostile actions taken against an individual because of that individual's sex, such as rape, sexual battery, molestation, or attempts to commit these assaults. Physical acts of a sexual nature, including touching, pinching, patting, grabbing, kissing, hugging, brushing up against another employee's body, or poking another employee's body. Interfering with, destroying, or damaging a person's workstation, tools, or equipment, or otherwise interfering with the individual's ability to perform the job. Sabotaging an individual's work, bullying, yelling, and name-calling. It's important to note that sexual harassment is in the eye of the beholder, not the eye of the harasser. So it doesn't matter what your intent was, it matters how it's perceived by the other person. Quid pro quo is a legal term meaning this for that. I do this for you, you do that for me. So it's usually about a balance of power where one person has the authority to make business decisions over the other. Quid pro quo sexual harassment includes offering or granting better working conditions or opportunities in exchange for a sexual relationship, threatening adverse working conditions like a demotion, shift alteration, or work location change, or denial of opportunities if a sexual relationship is refused, using pressure, threats, or physical acts to force a sexual relationship, or retaliating for refusing to engage in a sexual relationship. Who can be the target of sexual harassment? Sexual harassment can occur between any individuals regardless of their sex or gender, including male-to-male sexual harassment and female-to-female sexual harassment. New York state law protects employees, paid or unpaid interns, and non-employees, including independent contractors and those employed by companies contracting to provide services in the workplace. The offender can be anyone in the workplace, including a coworker, a supervisor or manager, or any third party, non-employee, intern, vendor, customer, visitor, building security, etc. Harassment can occur whenever and wherever employees are fulfilling their work responsibilities, including in the field, at any employer-sponsored event, training, conference open to the public, and office party. Employee interactions during non-work hours, such as at a hotel while traveling or at an event after work, can have an impact on the workplace. Locations off-site and off-hour activities can be considered extensions of the work environment. Employees can be the target of sexual harassment through calls, texts, email, and social media. Harassing behavior that in any way affects the work environment is rightly the concern of management. Sex stereotyping occurs when conduct or personality traits are considered inappropriate simply because they may not conform to other people's ideas or perceptions about how individuals of either sex should act or look. Harassment because someone is performing a job that is usually or was previously performed mostly by persons of a different sex is sex discrimination. An employee has the legal right to come forward with a claim in good faith without the risk of retaliation. Any employee engaged in protected activity is protected by law from being retaliated against. Some examples of protected activities with regard to harassment include making a complaint to a supervisor, manager, or another person designated by your employer to receive complaints about harassment, making a report of suspected harassment even if you are not the target of harassment, filing a formal complaint about harassment, opposing discrimination, assisting another employee who is complaining of harassment, or providing information during a workplace investigation of harassment, or testifying in connection with the complaint of harassment filed with a government agency or in court. Retaliation is any action taken to alter an employee's terms and conditions of employment, such as a demotion or harmful work schedule or location change, because that individual engaged in any of the above protected activities. Such individuals should expect to be free from any negative actions by supervisors, managers, or the employer motivated by these protected activities. Retaliation can be any such adverse action taken by the employer against the employee that could have the effect of discouraging a reasonable worker from making a complaint about harassment or discrimination. The negative action need not be job-related or occur in the workplace and may occur after the end of employment, such as an unwarranted negative reference. What is not retaliation? A negative employment action is not retaliatory merely because it occurs after the employee engages in protected activity. So as an example, if you were to be written up for your attendance after you've made a sexual harassment claim, that is not retaliatory just because it followed the claim. Employees continue to be subject to all job requirements and disciplinary rules after having engaged in such activity. Supervisors and managers are held to a high standard as it pertains to sexual harassment. This is because they're placed in a position of authority by the employer and must not abuse that authority. In the eyes of the law, a supervisor is an agent of the organization. So what the supervisor knows, the organization knows. If that supervisor has knowledge about sexual harassment and fails to act, the organization failed to act. Their actions can create liability for the employer without the employer having an opportunity to correct the harassment. They are responsible for any harassment or discrimination that they should have known of with reasonable care and attention to the workplace for which they are responsible. If a supervisor or manager receives a report of harassment or is otherwise aware of harassment, it must be promptly reported to the employer without exception, even if the supervisor or manager thinks the conduct is trivial, even if the harassed individual asks that it not be reported. Supervisors and managers will be subject to discipline for failing to report suspected harassment or otherwise knowingly allowing harassment to continue. What should I do if I am harassed? We cannot stop harassment in the workplace unless management knows about the harassment. It's everyone's responsibility. You are encouraged to report harassment to a supervisor, manager, or other person designated by your employer to receive complaints, as outlined in our sexual harassment prevention policy, so the company can take action. Behavior does not need to be a violation of law in order to be a violation of company policy. We will provide you with a complaint form to report harassment and file complaints, but if you're more comfortable reporting verbally or in another manner, we will still follow up on the sexual harassment prevention and investigate the claim. If you believe that you've been subjected to sexual harassment, you are encouraged to complete the complaint form and submit it to me, Melissa Houghton, Director of Human Resources. You may also make reports verbally. Once you submit this form or otherwise report harassment, CWI will follow its sexual harassment prevention policy and investigate any claim. You should report any behavior you experience or know about that is inappropriate as described in this training, without worrying about whether or not it's unlawful harassment. Individuals who report or experience harassment should cooperate with management so a full and fair investigation can be conducted and any necessary corrective action can be taken. If you report harassment to a manager or supervisor and receive an inappropriate response, such as being told to ignore it, you may take your complaint to the next level as outlined in our policy under legal protections and external remedies. Finally, if you are not sure you want to pursue a complaint at the time, you should document the incident to ensure it stays fresh in your mind. What should I do if I witness sexual harassment? Anyone who witnesses or becomes aware of potential instances of sexual harassment should report it to a supervisor, manager, or designee. It is unlawful for an employer to retaliate against you for reporting suspected sexual harassment or assisting in any investigation. It can be uncomfortable and scary, but it's important to tell coworkers that's not okay when you're uncomfortable about harassment happening in front of you. Anyone who engages in sexual harassment or retaliation will be subject to remedial and/or disciplinary action up to and including termination. An investigation of any complaint should be commenced immediately and completed as soon as possible. The investigation will be confidential to the extent possible. Any employee may be required to cooperate as needed in an investigation of suspected sexual harassment. CWI will investigate all reports of harassment, whether information was reported verbally or in writing. It is illegal for employees who participate in any investigation to be retaliated against. Our organization also has a duty to take appropriate steps to ensure that harassment will not occur in the future. CWI will conduct an immediate review of the allegation and take any interim action. Relevant documents, emails, or phone records will be requested, obtained, and preserved. Interviews will be conducted with parties involved and witnesses and investigation documented. The individual who complained and the individuals accused of sexual harassment are notified of final determination and that appropriate administrative action has been taken. Here are some examples of landmark sexual harassment cases. Barnes v. Train, 1974, is viewed as the first sexual harassment case in America, though the term was not yet used. Williams v. Saxby, 1976, defined quid pro quo sexual harassment. Williams was fired in retaliation for refusing the sexual advance of her supervisor. Meritor Savings Bank versus Vinson, 1986. The Supreme Court first recognized sexual harassment as a violation of Title VII of the Civil Rights Act of 1964. It established the standards for analyzing whether conduct was welcome and the levels of employer liability, and that speech or conduct in itself can create a hostile environment. Jensen versus Evelyn Mine, 1991, became the first sexual harassment case to be given class action status, which paved the way for others. 15 women settled for $3.5 million. Farragher versus the City of Boca Raton, Florida, 1998, ruled that employers are liable for harassment by their employees. And Oncal versus Sundowner Offshore Services, 1998, set the precedent for same-sex harassment. That was a male-to-male sexual harassment case. Following the ruling of Meritor Savings Bank versus Vinson in 1986, sexual harassment cases grew from 10 being registered to the EEOC the year before to 624 cases being reported in the following year. In addition to what we've already outlined, employees may also choose to pursue outside legal remedies. An individual is not required to make an internal complaint in order to pursue any of these additional outside options. A complaint alleging violation of the human rights law may be filed either with the Division of Human Rights or in New York State Supreme Court. Complaints may be filed with the Division of Human Rights anytime within 3 years of the alleged sexual harassment. You do not need to have an attorney to file. More information can be found at www.dhr.ny.gov. If an individual did not file at the Division of Human Rights, they can still sue directly in state court under human rights law within 3 years of the alleged sexual harassment. An individual may not file with the Division of Human Rights if they've already filed a human rights law complaint in state court. An individual can file a complaint with the EEOC, the Equal Employment Opportunity Commission, anytime within 300 days from the alleged sexual harassment. You do not need to have an attorney to file. A complaint must be filed with the EEOC before you can file in federal court. More information can be found at www.eeoc.gov. If an individual files an administrative complaint with the Division of Human Rights, they will automatically file the complaint with the EEOC to preserve the right to proceed in federal court. Many localities enforce laws protecting individuals from sexual harassment and discrimination. Contact your county, city, or town to find out if laws exist. Harassment may constitute a crime if it involves things like physical touching, coerced physical confinement, or coerced sexual acts. Contact your local police department. Any harassment or discrimination based on a protected characteristic is prohibited in the workplace and may lead to disciplinary action against the perpetrator. Age, race, creed, color, national origin, sexual orientation, military status, sex, disability, marital status, domestic violence victim status, gender identity or expression, family status, predisposing genetic characteristics, and criminal history. Much of the information presented in this training applies to all types of workplace harassment. Workplace harassment can be based on other things and is not just about gender or inappropriate sexual behavior in the workplace. After this training, all employees should understand what we have discussed, including how to recognize harassment as inappropriate workplace behavior, that harassment due to any protected characteristic is prohibited, why workplace harassment is employment discrimination, that all harassment should be reported, and that supervisors and managers have a special responsibility to report harassment. With this knowledge, all employees can achieve appropriate workplace behavior, avoid disciplinary action, know their rights, and feel secure that they are entitled to and can work in an atmosphere of respect for all people. CWI's Sexual Harassment Policy and Complaint Form can be found in the Everyone folder under Personnel Policies and Procedures. Thank you for attending this important training.